Hello, everyone, and thank you for joining us at Tab Talk series, avoiding redevelopment legal pitfall. My name is Dawn Bembry Breeden, and I'm the manager of Brownfields Redevelopment here at NJIT Technical Assistance for Brownfield Communities, better known as NJIT Tab. Every business, industry, and government entity have a role to play in protecting our environment, but ensuring they follow the rules is no small task. Environmental laws exist to safeguard our air, water, and natural resources, yet navigating the complex web of regulations can be challenging. That's where today's speaker comes in. I am so thrilled to be joined by my good friend and legal expert, Wanda Chin Monahan. Wanda is the owner and managing member of her own practice, the Law Office of Wanda Chin Monahan, LLC, based in Westfield, New Jersey. Wanda will shed light on how regulatory compliances shape the future and why it matters more than ever. So please join me in welcoming my friend, Wanda Chin Monahan. Hey, Wanda, how are
Hey,
you?
Dawn. I'm fine, thanks. And thanks so much for that introduction. And I want to thank you and the NJIT team for inviting me to participate in this webinar today. I've been practicing environmental law for a little more than 30 years, getting started as being a deputy attorney general representing the state NJDEP. And, since that time, I've been, in private practice and, really still doing a lot of the site remediation and brownfields redevelopment work, mostly for private clients now, but I still do represent a number of public clients as well. So I'm looking forward to this webinar, and I hope, the attendees, find it informative. And certainly if you have any questions, please feel free to place them in the chat room. We'll try to monitor that as we go along. And then we'll have some time at the end, I think, of the webinar for questions as well.
Okay, Wanda, let's get started. I'm ready. You ready?
I'm ready.
All right. So, Wanda, you know environmental law covers a broad range of issues, from corporate compliance and regulations to conservation and climate change policy. Can you describe your area of expertise and the type of cases that you typically work with? And Wanda, we have a lot of questions here, so let's try to minimize it so we can get through as much as possible, okay?
Yes, absolutely. I'll try to be brief. So, the majority of my practice, environmental law is obviously a very big field, as you pointed out, Dawn. But I would say that really where our expertise and core competence practice is in representing regulated parties in the buying and selling of either known contaminated sites or suspected contaminated sites, the very definition of what a brownfield site is in New Jersey. And our role, if we're representing a buyer of contaminated properties, is to work very closely with an LSRP or a consulting firm to do the due diligence so that our client knows exactly what they're buying, to identify the environmental issues that still remain for a particular piece of property, trying to quantify what those costs might be, and seeing whether or not the remediation of what remains to be remediated can be incorporated into the proposed redevelopment.
So, Wanda, what are some of your biggest legal challenges that you've seen companies having to face today, and how can they stay in compliance with environmental regulations?
I think probably the biggest issue for buyers and sellers is making sure that there's some finality to their environmental legal liability. So, someone who is selling contaminated properties, the majority of the time, they want to know that when I sell this property, that I'm done. No one's going to come knocking on my door, whether you, the buyer, or the NJDEP, et cetera. And so most oftentimes the allocation of environmental liability, as well as the associated costs, get negotiated during the negotiation of the purchase and sale agreement and or during the due diligence, because you don't really know, what's at the property until the buyer gets into some due diligence. And then, perhaps there has to be an amendment or two to the PSA agreement.
Excellent. So, as you know, NJIT Tab is a program based at NJIT that provides free services. This is my plug, right? Free
Yeah.
technical assistance, guidance, and training to communities and municipalities and other stakeholders involved in the redevelopment of brownfields. Wanda, in your own words, how would you define a brownfield site and how does it differ from any other contaminated sites, properties?
Yeah. Yeah, again, the law in New Jersey defines a brownfield site as either a known or a suspected contaminated site. And I'm so glad that you did that plug for NJIT because oftentimes, there is a lack of resources, right, that end up being an impediment to, let's say, an interested buyer and an interested developer. It's sort of a, posturing. Nobody wants to spend the money because you don't know what kind of, Pandora's box you might be opening. And so to be able to access and bring NJIT in as a partner, at least just to do some preliminary assessment and maybe some site investigation work, you just need sort of the foundation basis of environmental information. And then the buyer and seller and their environmental professionals really can take it from there. It's when you have a piece of property that nobody knows anything about, right? That there's really no environmental history, that everyone is afraid to look at the property, and a program like NJIT can, even through direct assistance to the municipality, can at least, that could be their contribution to this public-private partnership, for a property that's maybe laid fallow for, decades or whatever.
Wanda, do you need a job in our marketing department? You did a great job with that one. Okay.
I just think that
Thank
there's
you.
so many great public resources out there, Dawn. And,
Mhm.
when you're in the business, the way we are, we're familiar with it. But I think what would be so important is to really get that information out to townships and to counties and to redevelopment agencies, because it's a way for them to provide financial contribution, to assess a property, within their county, within their town, without their having to find the money within their own very limited municipal budgets.
And this is off script. I just want you to elaborate briefly on perceived contaminated sites. Sometimes people think a brownfield has been identified as a contaminated site. Can you elaborate on perceived environmental brownfield site? Can you elaborate on that?
Yeah, I think that again, where I like to counsel my clients is that knowledge, information is power. When you know nothing, you're powerless to make a decision, an informed decision to either move forward or to walk away. And that's why these programs are so important, because they can provide, again, just that modicum of foundation information about the environmental conditions of a particular property. There could be a property that, shuttered, 20 years ago, and people think, oh, that site, was used for manufacturing. It must be contaminated. And I'll be honest, it likely is contaminated, but what you
Mhm.
really want to know is how contaminated is it? And is it the sort of thing that can be remediated at an estimated cost that folks can rely upon, but then be integrated into the redevelopment? I'm sure that, you and all the attendees of this webinar are familiar with the fact that, for non-residential redevelopments, capping is such an appropriate remedy. Well, the developer, the buyer of the property, they have to build a building foundation. They have to build usually an asphalt parking lot. They have to put in landscaping. Those things can serve a dual purpose. So it's not extra money for the builders or the developers. It's part of their pro forma anyway in terms of their construction costs.
Excellent. Okay, Wanda, let's talk about an example of a successful brownfields project that you've been a part of. Let's take it from conception to completion, or where you got involved, so that people will know how the environmental regulations or understanding the strategy would be beneficial. So give me an example. We'll give someone an example of
Mhm.
a successful project you've been involved in.
Yeah, well, there's so many really, frankly, to choose from, but I'll try to pick something that, has some context to our attendees of this webinar. And I'll even talk about it from a generic perspective, because I think that what I do day in and day out does translate into really just about any site out there. And so what I would urge folks is to get a really qualified, experienced environmental team in place if you're looking to acquire a piece of property. A good environmental lawyer, but really also a really good environmental consulting firm. Because the first thing you want to do is you want to do a phase 1/preliminary assessment in order to establish your legal protections, both under New Jersey state law, but also under federal circle law as well. And through the conduct of the phase 1 PA, which generally speaking is not a very big cost, and or if you're able to tap into, grant funds through either NJIT or DEPs and EDAs, a hazardous discharge site remediation fund through the municipality, it provides you with a really good, again, foundation of, hey, you know what, this site has 10 areas of concern. We'd have to take some samples to either confirm or reject that there's actual contamination here. And usually, of the 10, say, identified actual or potential areas of concern, usually a few of them drop out once you've sampled. You think maybe there was soil staining, but when you actually take the samples, there's nothing, above the cleanup standard. And then so when you go from there and you have the confirmed contamination in a discrete number of areas of concern, once you have a good cost estimate, that environmental consultant who hopefully has a lot of brownfields experience will be able to work with the client to say, hey, are you going to be building a foundation for the building? Are you going to be putting pilings in? How much of a parking lot area do you need? So that, again, you can integrate both the required remediation with the proposed redevelopment.
Excellent. So, okay, Wanda, with the context of brownfields, we have what's called an innocent landowner defense, which often comes up, particularly in environmental law. This defense allows property owners, such as innocent landlords, to avoid liability for contamination on their property, as long as they can prove that they did not cause the contamination and was not aware at the time of acquiring the property. So what kind of due diligence, and I know you mentioned the phase 1, and I'm an environmental consultant, so I'm really familiar with the phase 1 that results to a phase 2, and prayerfully not a site remediation process, but most times it does. Give us an example of the required due diligence, which I discussed just now, and what are the potential legal consequences if the contamination is found during redevelopment, meaning they got to the site remediation piece, and then there's contamination, more contamination. How is the innocent landowner protected?
Right. So one thing I want to point out, Dawn, is that the protection under CERCLA is an innocent landowner defense. A defense in legal terms is completely different than an exemption from liability. So the agency, the EPA or whomever, can still go after you, and you can raise as a defense to that lawsuit, wait a second, when I acquired the property, I did my all appropriate inquiry by doing the phase 1, phase 2, and I knew what I was getting into. What's being found now was not discovered during the phase 1 and phase 2. And this also pertains to the innocent purchaser defense under the Spill Act here in New Jersey, because the agencies want to know that you've armed yourself with knowledge about the property and that you're willing to still move forward, but you're also willing to investigate and remediate what you did find during your due diligence. So again, but for me, as a lawyer, the key takeaway is to remember those are defenses only. They are not an exemption from liability.
So who would be held liable in the event that as they're doing the remediation, they come up with existing new environmental
Right.
concerns? Who
Yeah.
would be?
Well, it would go back to, the original dischargers, the previous, owner operator of that property. But again, I like to infuse practical, common sense when I'm dispensing legal advice, right? And so what I say to clients who are going to buy these properties, and I explain, the establishment of these innocent landowner, innocent purchaser defenses. The fact of the matter is, though, you are going to own this property. That asset is going to be your asset. So, if new contamination is found in some corner of the property you didn't know about, are you really going to ignore it? Or are you really going to say, okay, well, I'm not responsible, so I'm not going to do anything about it? The fact is, at some point, you're going to be looking to perhaps get a tenant or more than one tenant, for, let's say, this new industrial park, that you're building at the property, you're going to want to go to permanent construction financing. And then at some point, maybe you want to sell the project once it's completed. Well, all of those folks that I've mentioned will all have environmental professional teams doing their due diligence. And if they become aware of that corner that has contamination that you didn't address, that's something that you're going to have to explain, and it's going to be, put into the column of potential environmental risks for either the tenant or the construction loan, permanent financing, or, the eventual buyer, let's say, of the newly redeveloped property. So again, from a common sense perspective, I try to make them understand that the defense, in my view, is of limited protection because you've already spent whatever, $12 million to buy this property. You're infusing another $15 million for remediation and redevelopment. You have a lot of money invested into this property.
Mm-hmm.
And are you really going to stop to try to find that previous historic user owner to go after them? You've got construction and remediation people on site already. You're more than likely going to, in order not to stop your construction, just go ahead and have them take care of it. But hopefully, if we've done our job right as an environmental professional team, hopefully you won't find that pocket of contamination that nobody knew about. But it does happen. Don't get me wrong, it does happen, Dawn.
Okay. So I think you touched on this, but I want to make it very clear. Can you explain the key environmental law that governs brownfields redevelopment, such as CERCLA, Superfund, and the Brownfields Revitalization Act? Can you talk a little bit about that?
Yeah, so again, I think the brownfield statutes, both on the state New Jersey level and on the federal level, were, a recognition that there are properties that are contaminated that, the discharges may no longer be around or they may not be financially viable. And if you have an innocent, a developer who has nothing to do with the property and they're willing to voluntarily, take on the responsibility, why would you turn that away? Why wouldn't you enact these statutes as they have both in New Jersey and at the federal level to provide at least some protections? Because there's one thing that developers really want, and that's certainty. Right. So they know when they're buying these properties to redevelop them, if they know how much it's going to cost to remediate it through to the issuance, let's say, of an NFA or a response action outcome, they know that's the extent of their liability, right? And they have finality, which is so important. And so if they can understand that and it pencils out, in their pro forma with all the other financial factors that, come into play with a redevelopment project, then it's a go. So the brownfield statutes, both state and federal, really, I think, broke open wide all this redevelopment, frankly, that we've been seeing for the past, almost 20 years now.
Mm-hmm. So what are some legal protections available for developers or municipalities, sorry, looking to redevelop a brownfield site? For example, how do bona fide prospective purchasers protections work?
So, sort of similarly as to those other defenses, right? Being a bona fide, purchaser is very similar to being an innocent purchaser in New Jersey. But I do want to talk a moment, Dawn, about the protections that a municipality can have, because I think that oftentimes they're not armed with the knowledge of what legal protections are out there. I made a distinction before between defenses for environmental liability versus exemptions. And what I think some municipalities are not aware of is that in the Spill Act, if a municipality acquires the property involuntarily, which includes taking it by tax foreclosure or by condemnation, there is an absolute exemption for liability for that township. So, what that does for a municipality is now they have control over that property and they can go ahead and, again, apply hopefully for grant funds to either do some initial preliminary assessment or site investigation work to get that foundation of information, and then go out to, the development community to say, hey, we've got this 4-acre site. It's really not as bad as everybody thinks. Here's a recently conducted PA phase 1 report. Give us your best ideas of, what you want for the property. And depending on how the municipality acquired the property, whether it's through tax lien foreclosure or through condemnation, it's more likely that the township really hasn't expended any monies to acquire that property, right? So they may be able to make it more financially advantageous for a developer to look at that particular property, because there's definitely leeway, negotiation room for the developer's acquisition costs. Maybe the township wants 50 cents on the dollar on the tax liens, or some negotiation so that the township can, get something, out of the property. But again, that's one way for municipalities to be able to take action without fear of now being impugned with environmental liability, because those two circumstances, as I said, do provide an absolute exemption from environmental liability.
Let me just clarify something. When you mentioned a preliminary assessment, that's for New Jersey. So most
That's
states
correct.
are not required to have a preliminary assessment. Could you
That's right.
explain how some of the requirements you're talking about, are they applicable to other states, or are you just talking mainly about New Jersey?
I'm really talking about mainly about New Jersey, but as I said, in order to establish the protections, the defenses under the federal laws, CERCLA in particular, I always advise my clients to do both, hire the consultant to do a hybrid report so that you satisfy the New Jersey standards. Because if the property is in New Jersey, you're going to want an LSRP to issue an RAO at the end of the day. If you don't do a preliminary assessment and you only do a phase 1, that won't qualify.
Right.
The LSRP won't be able to issue the RAO.
All right. I just wanted to make sure, because we have participants from all over. So I don't
Yes.
want us to use jargons and
Yes.
directions that's not applicable to that state. So
Right.
you would advise them to what? Contact their local, if they're in another state.
Absolutely.
Okay.
Yeah, absolutely. And you asked me earlier, offline about doing environmental legal work in other states other than New Jersey. And while I have a law license in a couple of other jurisdictions, I really tend to shy away because I don't feel like I'm an expert in those other jurisdictions. That is, I don't know the local state laws as well as I know them here in New Jersey, and I'd prefer to refer a client to a lawyer who does really practice, predominantly in that jurisdiction. So I think you do have to always keep the federal laws in mind, but also the state and the municipal laws in whatever town or state you're working in.
So before we move on to zoning, I have one final question in this area.
Sure.
Are there any strategies for mitigating liability risk when acquiring or redeveloping brownfields? What's some strategies?
Yeah, absolutely. So again, assuming you've done some initial, preliminary assessment phase 1 and phase 2 site investigation work, and assuming the consultant is able to come up with a good, reliable cost estimate to finish the remedial investigation and then conduct the remediation. And let's say that estimate is a plus or minus, 10%, which I think is usually the case. For sites that are very large and that have a really long industrial history, and I've got many of those sites, we also will ask the client whether or not they want to pursue getting a pollution legal liability insurance policy, a PLL. And I won't go into all that. That could be a webinar all by itself, PLL insurance. But just know that there are insurance companies that still offer a PLL policy, and it predominantly will give you coverage for unknown pre-existing historic contamination. So you've done your PA, you've done your phase 1, your phase 2, your site investigation, and so forth. You send that to their carriers. They have their environmental people looking at it. And so if they're comfortable that that work was done completely, then they'll offer a PLL policy for that circumstance, Dawn, that we talked about earlier, that as you're doing construction, all of a sudden you find this 3 underground tanks in some corner of the property that didn't show up in the PA or phase one, you would have a claim under that insurance policy for the investigation and remediation of that, unknown pre-existing historic condition. And the other piece of the PLL policy I always recommend to clients is, the PLL is good for 10 years. You can also get, in addition, a 5-year policy for any new environmental pollution conditions. So you own the property, you redevelop it, and some, tanker truck comes by and spills his load on your property. First, you'd go after that person's, that trucking company's insurance. You'd also have your own policy to go after as well, because now you've got coverage in place for 5 years for new pollution conditions.
After you've had a heart attack and they reluctantly want to give you the money. That's what happened.
And I'll just say, Dawn, most of what I say is because I've actually had a case like that. So I represented a residential apartment developer who was located along Route 22 here in New Jersey. And exactly that happened. There was an accident. A fuel truck, got into an accident with a few cars, spilled over and, dumped fuel all over my client's property. So we were able to, get the trucking company's insurance to pay, which they should have. But, in the event, they're insolvent or they're not properly insured, you have the benefit of this PLL policy if, you put it in place.
Excellent. So let's get into zoning. We're understanding zoning and property development in the context of brownfield projects is vital because these factors play a crucial role in the successful transformation of a contaminated site into usable, safe, and productive spaces. How do zoning laws impact the redevelopment of brownfield sites?
Yeah, that's a great question, and I think an area that sometimes the environmental professionals don't really get involved in, right? But I've tried throughout my career to learn a little bit about all of the related disciplines. I'm not a zoning or a land use lawyer, but I've tried over the years to learn from my colleagues so that I can understand how the context of those issues play into my role in terms of the environmental. But one of the tools that, again, here in New Jersey, Dawn, that municipalities have is the redevelopment and housing law, right? They have the ability to designate one or more properties as an area in need of redevelopment. And when they do that, it opens up so many options for both the municipality as well as a potential developer, really, I think, in two major ways. Once an area in need of redevelopment has been formally adopted, there's a redevelopment plan that likewise gets presented and adopted. Once that redevelopment plan is adopted, that serves as the overlay zoning for all the properties in the designated redevelopment area. And the plan will usually lay it out one of two ways. They'll either list prohibited uses, and basically everything that's not prohibited is allowable, or they will have a list of permitted uses. But the beauty of the redevelopment plan is that, if the right developer, the right project comes along, you can go ahead and amend that redevelopment plan. Like, let's say, for instance, I don't know, warehousing, was on the list of prohibited uses. But, as the municipality goes out to the development community and every other developer coming in says they want to do a warehouse, well, then maybe they'll rethink and go ahead and amend that redevelopment plan to make warehousing as an acceptable zoning. But again, that's something that, is so important because you want to know, can you build on this property what you want to build? The second real tool in a designated redevelopment area is that a municipality can offer something called a pilot, a payment in lieu of taxes, which is very advantageous for a developer buyer. I'll use simple math. Let's say the conventional real estate taxes are $100,000 for a particular piece of property, but they haven't collected that money because the property's been abandoned for 20 years. And a developer comes along and says, I really need to get a pilot instead. Can you give me a pilot to pay $70,000 a year instead over the next, 10 years? So the advantage to the developer is clear. They're going to save $30,000 a year from not paying conventional taxes by paying these pilot payments to the township. The advantage to the township is that under conventional taxes, a very large portion of conventional taxes goes to the local school board.
Hmm.
So
I
I
didn't
think
know
it's
that.
usually about 40%. So let's say on that
Mhm.
100,000, the township's only realizing 60,000, right?
Mhm.
And
Mhm.
so if they enter into a pilot agreement with the developer, and let's assume that that proposed development is not going to uh, create any additional school-aged children, say like a storage facility or an office building or a retail center or whatever, the township is better off entering into a pilot agreement because now they're going to realize 70%, I'm sorry, $70,000
Mhm.
in pilot payments that they don't have to share with the county or their school board. And the school board really shouldn't have, much to gripe about because this property is not creating additional school children. So anyway, that was a little bit of an aside from, you
No, because
know,
here's the question I have with that is how would a developer know all that's available to them and we're going to talk a little bit about the tax
mhm,
incentives, but you touched on other things. How would a developer know just to proceed that way? I mean, they get an
well,
attorney, they gotta hope their attorney knows all this information to save them some money. But
yeah.
where would they go to get that information? Is there a checklist? Is there something
Mhm,
available before they go and secure um
mhm.
an attorney?
Right. So what I would say is that most towns in New Jersey are much better about putting this kind of information on their websites. Right. So
Okay.
that's the first thing I would do. I would go ahead and go right on the township website to see whether or not they have any areas designated as areas of in need of redevelopment. And if so, then you have to go find the redevelopment plan, which usually also is on the websites. But if the township hasn't gotten that far, or they're really not that familiar with this law, the redevelopment and housing law, then it's really up to the developer and their team to educate, the town in terms of, this is how we could really work in partnership together, this public-private partnership. What
Mm-hmm.
what I like to remind my private client developers is, the towns that you're going into, just know development is not what they do. They're worried about getting the garbage picked up. They're worried about, the traffic. They're worried about
Mm-hmm.
crime. So you as the developer, because this is what you do, it's almost incumbent upon you to educate and inform the township that you want to maybe find a property to redevelop in.
Mm-hmm.
So that sometimes that's how it comes about as well.
Okay. Thanks, Wanda. Okay, long-term considerations for brownfield sites are important because they
Mhm,
ensure proper environmental remediation, sustainable development, and economic viability. A
mhm.
long-term approach helps manage risk, supports community well-being, and ensure compliance with regulation. It also allows for the incorporation of climate resilience and social improvement, making the redevelopment beneficial for future generations. What ongoing monitoring and reporting is required after the brownfields remediation?
So oftentimes, and again, I'm predominantly speaking here in New Jersey, oftentimes uh, the remediation includes engineering controls, which are mostly capping of the
Mhm.
residual contamination. That also requires the filing of a deed notice to let the general public know that at this property we've left behind some moderately contaminated soils beneath a protective cap. And in New Jersey, with that comes having to apply for and obtain a soil remedial action permit from the NJDEP. And what that permit does is it sets forth what the ongoing operation maintenance requirements and reporting requirements are for that cap. Because DEP doesn't view a capping remedy as a quote final remedy, right? Because
Right.
that remedy is only protective as long as that cap stays intact, right? So under the soil remedial action permit, there is a requirement for an LSRP to do an annual inspection of the cap,
Mhm.
and then every 2 years, biannually, the LSRP has to sign a certification that they've inspected the cap the last 2 years and that it's still fully protective. Or, over time, if there are cracks in the pavement, if there are, any areas that need to be repaired, that they have in fact been repaired, and so therefore the cap is still fully protected. So developers know and understand that when they do what DP considers a non-permanent remedy like capping, that there are, future long-term regulatory reporting and monitoring and maintenance, obligations. But, when it comes to a new development, again, that developer has put millions of dollars into the property and has likely a tenant in the new building. They're not going to let the parking lot, deteriorate, right? They're going to not so much, I'll just say it, not so much for the environmental protection, but again, as a
Mhm.
practical matter, they're going to want that parking lot to, the pavement to be, smooth and, without cracks and so forth. So they're going to go ahead and repair it. Again, more in my mind for business reasons, but it also serves the dual purpose of satisfying the long-term environmental obligations.
So have you seen or experienced a capping that required additional environmental or construction work or didn't pass the
Mm,
inspection, the biannual inspection? Have you seen that?
yeah,
Because
I
there are
really
capping requirements, so they tell you exactly how to cap it. But
right.
what happens when there's a damage done to the
Mhm.
capping? Um, is
Yeah, again, Dawn, you have the obligation to make repairs so that that cap is still fully protective. But,
mhm.
sort of in my experience, I think that that decision is made more on a business side than necessarily, on the environmental side.
Do you find it easy to transfer property or sell property once a deed notice has been issued, identifying that there's some left contamination, basically?
Yes, yes.
Have you found it being difficult to transfer or sell property?
No, not at all. In fact, I think that the community here in New Jersey is mostly very savvy and knowledgeable about the regulatory requirements. And so, when you're a buyer and you're taking a look at a property that already has a deed notice, already has an existing soil, remedial action permit attached to it,
Mhm.
those are things that get negotiated with regards to who's going to pay for the next 30 years of the monitoring and maintenance and repair requirements and the reporting requirements under that soil wrap. And DEP has a soil wrap transfer form, right, that can transfer that responsibility to a new responsible party or to a new owner, depending on what business terms the buyer and seller reach. So it's very common, to transact these properties both with deed notices and remedial action permits associated with them.
Okay. And we're coming to a close because we do want to get to some of the questions and
Yes,
answers
of
because
course.
I see quite a few input into the chat. But we're not closing yet because I do have a couple of more questions and
Okay.
just explain some incentives or tax benefits for redeveloping. And I think you touched on it,
Mhm.
but just give a broad view of what are some tax
Yeah. So
incentives.
I did mention, the payment in lieu of tax,
Mhm.
availability only for those properties that have been through the redevelopment designated process, by the township or by a redevelopment agency. I'm also aware through EDA, our good friends Dawn over at EDA, they have a Brownfields tax incentive program.
Elizabeth.
Yes, exactly. It's a pretty, I'll just say it, it's a pretty arduous process to go
Mhm.
through. But it's a great program in the sense that it is encouraging, and I'll say it's for much larger projects, right? You're not talking about using it for like a corner gas station. You're talking about using it for, property that's, tens of acres or 100 acres or whatever. And what the state has decided is that we're better off providing some tax benefit incentives for this property because right now we're not getting any monies from this property, state, local, or otherwise. And so if we're willing to, for a short term, forego some of those tax revenues in order to make it financially feasible for a developer to take on the project, it gives the developer some relief upfront with those tax incentives. And then at some point, those tax incentives will uh, be completed, and then that property will be back on the normal either pilot payments or conventional taxes. But I think it's a great recognition by the state here in New Jersey that, without providing some financial incentives, you may have properties in the state that never get redeveloped because the cost to remediate is just too great. But if you can provide some tax incentives, because that's real money, right, to a developer, and it's real money to the state of New Jersey.
Okay. Here, this is important to me. So I'm going to break it down into sections. What advice would you give? Because I know we have developers online, we have nonprofit online, we have municipalities, we have legal people on participating. So I'm going to quickly just describe what advice would you give to, let's say, a local developer who have identified a site, and they want to proceed into doing remediation because it's a perceived contamination. They don't know. We know it's a due diligence process. But what recommendation you would give them in a short sentence to proceed and feel confident moving forward?
Yeah, I mean, I think that even before you have to hire the environmental professionals, right? There's nothing stopping that developer from submitting an OPRA request to NJDEP, identifying the property by its street address and block and lot number, and saying to DEP, if you have any files on this particular piece of property, please send them to me. An OPRA request is free to make. And then depending on the volume of documents they find, they may charge you, X, cents, per page to copy it and send it to you or whatever. But that's a pretty quick, easy way for a developer to get some information without having to engage environmental professionals right away. DEP has a great public resource called Data Miner. Same thing. There's a lot of information available on DEP's Data Miner website that a developer, again, assuming they know how to navigate, and I can tell you Data Miner can be a little challenging to navigate, but you can find a lot of great information about a particular piece of property, that way as well. But sort of short of that, I would also recommend that, maybe you start going to some of the township council meetings or the planning board meetings just to get a feel for, the political will of that town where the property is, and are they savvy about redevelopment? Are they savvy about environmental issues and things? But those are things I think you can do before you go through the time and expense of actually engaging environmental professionals.
And also GeoWeb, it provides a wealth
Oh,
of
yes.
information. So you can find, and you may be able to print some reports out from GeoWeb.
Absolutely.
Now, let's talk about, that was a developer. Let's talk about a nonprofit. So you have a nonprofit, let's say they see a piece of property across the street from where their office is at, and they really want to be a part of this redevelopment effort and get some funding to help them do the phase 1, phase 2. What recommendation would you give a nonprofit organization?
Yeah, so sort of similar, advice, Dawn, with regards to all these publicly available free resources, trying to find out as much as you can about the property. And again, I would, since they're, let's say, already have a presence in that township, again, try to meet with the mayor or some council people in that town and see whether or not they've ever had any experience to apply for grant funds from the DEP EDA's Hazardous Discharge Site Remediation Fund, the HDSRF fund, because a municipality can apply for that, again, free and whatever, and that will fund 100% of your preliminary assessment. It will fund 100% of your site investigation, and it will fund 100% of your remedial investigation. It falls just short of dollars for remediation.
Okay. Can you speak real quickly on the BDAs in the communities in New Jersey? I'm not sure, and probably New York have similar types of things, but could you speak briefly on the BDAs and what they do and how people can access them or information from the BDAs, which is go ahead.
Right. So, Dawn, the BDAs you're referred to as the Brownfields development area. And so a township or a county can apply for BDA designation from the DEP by proposing either one or an assemblage of parcels within their town. They don't have to be owned or controlled by the municipality. They could say, you know what, that old industrial section of our town, there's 4 properties there. We want a BDA designation. And so, you'd have to hire an environmental professional team likely to help you, prepare that application. It's a competitive process, but the advantage to being designated a BDA is you can receive up to $5 million for actual remediation. That's really, in my mind, the biggest draw of going for the BDA. But it can be a bit of an arduous process. But if it's an area of a town that can't seem to get off the ground otherwise, I would heartily recommend at least looking into that.
Okay.
Mhm.
Wanda, this is my final remark to you. I thank you. I'm so grateful.
Oh,
You did your thing. Thank you
it's
very
my
much.
pleasure.
Would you agree that, in summary, brownfield sites, if not properly managed, can pose significant environmental and health risks to surrounding communities? However, with thoughtful legal and environmental strategies, these sites offer immense potential in revitalization. Wanda, what is your final remark that people can have takeaways that you would recommend to anyone who lives in an area with a lot of brownfield sites, who
Mhm.
is looking forward to doing development and just helping them move from A to B with this process? What
Yeah,
would be your, this is our final question before we go to
yep.
questions and answers. So go
Yeah,
ahead.
no, absolutely, Dawn. And really, everything that I've said here during this webinar applies to your question, right? Whether you are a neighborhood watch group in a township, right? And,
Mhm.
there's that old, chemical company that's across the street from the elementary school, right? And you're worried about your children going there, playing in the playground, et cetera. The same thing, you have to take steps to find out more information about that site. And you have to go to your local elected officials to see what can they do about it. And again, I mentioned a lot of things with regards to the HDSRF grant programs, the brownfields, tax incentive programs, the area in need of redevelopment designation. There's a whole big toolbox out there, right? It's just a matter of whether or not the elected officials, have the political will to make that more of a priority, and being able to get traction for that kind of a project.
Okay, here's a question. Okay.
Mhm.
Because Wanda, you're typing the answer, okay? So it says brownfield sites is in an overburdened community, only information in PA from 2008. How to find, wait a minute. How can we find information that transpired in the past 17 years? I'm assuming this is from a guest. I don't want to say names, but
Mhm.
Wanda, how could they find information? I know there's historical documents like Sanborns and aerials and stuff, but how can they find information about a site? And I'm hoping I'm addressing this question correctly because I can't quite get it together here with this question, Brownfield site. But how can they address a site of 17 years ago?
Yeah, again, Dawn, I would, point them to all of those publicly available free resources to find out, information because the key to identifying environmental issues at a site starts with trying to find out as much information as you possibly can about the historic use and operation of the site, over, the decades since it's been developed, going from a vacant site to a developed site. And really, it's a little bit of a treasure hunt, when you start to look at those database resources in terms of what you're going to find. And if you don't really come up with anything, because let's say nobody has really ever looked at a property, and that unfortunately happens, right? Because these databases only get populated with information, if someone's
Mhm.
done work and goes ahead and submits it. Then really the only other way to do it is to hire an LSRP or consulting firm to do a full-blown preliminary assessment and or phase one environmental site assessment.
Okay, I have another question, and I'm looking at the time. It says
Yep.
municipality owns 5 acres closed landfill, brownfields,
Mhm.
closed by the DEP in 1978,
Mhm.
directly on the Salem, Delaware riverbank. What happens if the municipality is not interested in redeveloping or testing that site?
Yeah, so, that's, that sort of strikes right to the core of my heart, in terms of a municipality not being interested, right, in taking, really accountability if they own this, landfill. It's 5 acres. It's right on the Delaware River. I can imagine that the, residents of that particular municipality would want to see something happen with it, right? Because it's a closed landfill. It's probably got, some contamination, et cetera.
Mhm.
I don't know why a municipality wouldn't be interested in at least, pursuing redevelopment interest. There are really smart people out there and they have much better ideas than I have with regards to, from a marketing, from a real market perspective, what can really survive, and be successful on this particular property.
Okay. Um, let's say developers want certainty.
I absolutely
How,
agree with
but
that.
how have they handled or managed the uncertainty that will come up when the DEP revises their remediation standards? Yes, I know that. After an
Mhm.
RAO has been issued, where an order of magnitude or more changes have occurred, which makes the revised standard more restrictive than the standard to which the remediation was performed. In
Yeah.
this case, further remediation would be required. That is an excellent question.
That
Okay.
is yeah, that is really an excellent question, Dawn, and thank you, to, the person who submitted it, right? I
Mhm.
absolutely 100% agree, developers want certainty, and the only problem is that you're never going to, uh, be able to provide guarantees that DEP is not going to revise their remediation standards, right? Or change, the standards to be more than an order of magnitude. But if you've done the appropriate due diligence before acquiring the property and you establish your innocent purchaser defense, again, under the New Jersey State Spill Act, you
Mhm.
do have a defense, and again, a defense, not an exemption from liability, in that exact circumstance where, let's say you remediated contaminant A to a standard, say it's the standard was 100, and after you completed your remediation, DEP revises it to now make that cleanup standard 1 part per million. It's more than an order of magnitude change. You would not be responsible to do that additional remediation from the 100 to the 1 if,
Mhm.
again, you had the innocent purchaser defense established. So if DP were to sue you and say you need to do that incremental cleanup from 100 to 1, you would have that legal defense, and hopefully, if everything was done properly, you would be successful in that defense. And so, but relative to really, I think the more important question, it's, what if somebody comes along afterwards, right, to buy that property, and the
Mhm.
LSRPs and the consultants have to do an order of magnitude analysis. So let's say a site was remediated in 1982. The LSRP has to look at what was remediated, what contaminants were remediated, what the remediation standards were at that time, and then compare it to what the remediation standards are currently. And that's, where it comes, becomes a little sticky because, a new property owner, a new buyer, a new developer will be required if they want an updated and current response action outcome to be issued. They'll have to
Mhm.
do that incremental remediation.
Excellent. Okay, we have another question. We have two more, so hold on, don't leave us
Okay.
yet.
No, no.
Okay, I'm saying it to the participants. We still have participants, and I'm looking at the time because,
Yep.
but I want to get to these questions. Is important. Can you speak to the Brownfields tax credit? And we spoke briefly on that. What
Mhm.
are the conditions that will trigger access to them? In order for a developer to take advantage of them, does there have to be a contamination remaining? If a municipality cleans up the site and then sells it to a developer, does the cleanup by the municipality eliminates the developer's ability to use the brownfield tax credit? Interesting.
So
Mhm.
I won't pretend to be an expert on the EDA's Brownfields tax credit incentive program, and we can certainly provide you with resources directly to the folks who run that program at EDA. But I
Mhm.
would say that generally speaking, it really applies on a going forward basis, right? So if you've already completed remediation, you're not getting tax credits. These are supposed to be incentive programs. They're supposed to incentivize someone to take on remediation, right? So to the extent that work's already been performed, that won't qualify. But if you've got a project where the development hasn't occurred yet, and the building foundation, the parking lot will serve as a cap. Well, that's also still remediation, right? So that, hopefully that could qualify. But again, I think that, putting you in touch directly with the folks at EDA would really be my best advice, because I don't want to steer anybody wrong here on that program.
And I just see where Elizabeth Limerick put an attachment to the website. So you can get more clarification if you look at the chat here. She did put a website. So thank you, Elizabeth.
Thanks, Liz.
I am going to answer. We have 2 more. Hold on. Okay. Can you clarify how a pilot program could be utilized to help schools instead of hurt them? Are there any standard clauses around redevelopment supporting local school programs?
So I'm not aware specifically of any programs that will benefit a school board, but I've also had circumstances where a township will work in concert with their school board. So even though the township could cut out the school board by entering into a pilot agreement with the developer, they may enter into a simultaneous agreement with the school board to say, basically, even though you're not entitled to share in these pilot payments over the years, we agree to provide the school board X dollars or X percentage of the pilot payments that we collect, because the school board budget is, highly dependent on, the overall taxes that are collected in that town. And so once you enter into a pilot agreement, that property can never produce tax revenues if a pilot agreement is entered into. And so to, keep the peace, and hopefully the elected officials in the township have a good relationship with the school board, right? Because we're all, working towards, benefiting the residents and the children who live in the town and so forth. There's nothing stopping a township from entering into a side agreement with the school board to have them share in the pilot payments that are made.
Okay. We're up against time, but we do have another question that I think I'm going to reference it to Elizabeth, who gave her website, because this is about tax credit. And I know you're not the expert in that particular area, and the EDA is. So the question is, if you can answer it, that will be great. But I do want to say that the contact person is put the information in the chat. And it says, what would you say the success rate for getting the Brownfields tax credit getting granted, and have you ever seen it be denied?
Yeah, certainly. They can't approve every application for the Brownfields tax credits, and it is a highly competitive program, because there are only, certain dollars that can be allocated for it. But as I understand, EDA was rolling out different rounds of the Brownfields tax incentive credits. So I know round 1 has already been completed, but I don't know, Dawn, whether or not round 2 has opened up yet. But I would definitely check the EDA website, because they'll have all information about that right on their website.
Well, thank you again. And I'm going to turn it over to Fatima, who's going to give you upcoming events. And please join, because this is so exciting. I enjoyed myself. Wanda, did you have fun?
Thank you, Dawn. I did as well.
Thank you. See you. Bye.
You're welcome.